Draft version 1.
American Apologetics. A perusal of Dobbs v. Jackson. Leaked abortion case. Written and produced by Pacificatoris. Partout.
Respondents are an abortion clinic, Jackson Women's Health Organization, and one of its doctors. On the day the Gestational Age Act was enacted, respondents filed suit in federal district court against various Mississippi officials, alleging that the act violated this court's precedents establishing a constitutional right to abortion. The district court granted summary judgment in favor of respondents and permanently enjoined enforcement of the act, reasoning that viability marks the earliest point at which the state's interest in fetal life is constitutionally adequate to justify a legislative ban on non-therapeutic abortions, and that 15 weeks gestational age is prior to viability. We granted certiorari to resolve the question whether all pre-viability prohibitions on elective abortions are unconstitutional. Petitioner's primary defense of the Mississippi Gestational Age Act is that Roe and Casey were wrongly decided and that the act is constitutional because it satisfies rational basis review. Respondents answer that allowing Mississippi to ban pre-viability abortions would be no different than overruling Casey and Roe entirely. They tell us that no half measures are available. We must either reaffirm or overrule Roe and Casey. 2. We begin by considering the critical question whether the Constitution, properly understood, confers a right to obtain an abortion. Skipping over that question, the controlling opinion in Casey reaffirmed Roe's central holding based solely on the doctrine of stare decisis, but as we will explain, proper application of stare decisis required an assessment of the strength of the grounds on which Roe was based. We therefore turn to the question that the Casey plurality did not consider, and we address that question in 3 steps. First, we explain the standard that our cases have used in determining whether the 14th Amendment's reference to liberty protects a particular right. Second, we examine whether the right at issue in this case is rooted in our nation's history and tradition and whether it is an essential component of what we have described as ordered liberty. Finally, we consider whether a right to obtain an abortion is supported by other precedents. 1. Constitutional analysis must begin with the language of the instrument, Gibbons v. Ogden, which offers a fixed standard for ascertaining what our founding document means. The Constitution makes no express reference to a right to obtain an abortion, and therefore those who claim that it protects such a right must show that the right is somehow implicit in the constitutional text. Roe, however, was remarkably loose in its treatment of the constitutional text. It held that the abortion right, which is not mentioned in the Constitution, is part of a right to privacy, which is also not mentioned. And that privacy right, Roe observed, had been found to spring from no fewer than 5 different constitutional provisions: the First, Fourth, Fifth, Ninth, and 14th Amendments. The court's discussion left open at least 3 ways in which some combination of these provisions could protect the abortion right. One possibility was that the right was founded in the 9th Amendment's reservation of rights to the people. Another was that the right was rooted in the First, Fourth, or Fifth Amendment, or in some combination of those provisions, and that this right had been incorporated into the Due Process Clause of the 14th Amendment, just as many other Bill of Rights provisions had by then been incorporated. See also McDonald v. Chicago. And a third path was that the First, Fourth, and Fifth Amendments played no role and that the right was simply a component of the liberty protected by the 14th Amendment's Due Process Clause. Roe expressed the feeling that the 14th Amendment was the provision that did the work, but its message seemed to be that the abortion right could be found somewhere in the Constitution and that specifying its exact location was not of paramount importance. The Casey Court did not defend this unfocused analysis and instead grounded its decision solely on the theory that the right to obtain an abortion is part of the liberty protected by the 14th Amendment's Due Process Clause.
We discussed this theory in depth below, but before doing so, we briefly address one additional constitutional provision that some of respondents' amici have now offered as yet another potential home for the abortion right, the 14th Amendment's Equal Protection Clause.
Neither Roe nor Casey saw fit to invoke this theory, and it is squarely foreclosed by our precedents, which establish that a state's regulation of abortion is not a sex-based classification and is thus not subject to the heightened scrutiny that applies to such classifications. The regulation of a medical procedure that only one sex can undergo does not trigger heightened constitutional scrutiny unless the regulation is a mere pretext, designed to effect an invidious discrimination against members of one sex or the other. And, as the court has stated, the goal of preventing abortion does not constitute invidiously discriminatory animus against women. Accordingly, laws regulating or prohibiting abortion are not subject to heightened scrutiny. Rather, they are governed by the same standard of review as other health and safety measures. With this new theory addressed, we turn to Casey's bold assertion that the abortion right is an aspect of the liberty protected by the Due Process Clause of the 14th Amendment. 2. The underlying theory on which this argument rests that the 14th Amendment's Due Process Clause provides substantive, as well as procedural, protection for liberty has long been controversial. But our decisions have held that the Due Process Clause protects two categories of substantive rights. The first consists of rights guaranteed by the first 8 amendments. Those amendments originally applied only to the federal government, but this court has held that the Due Process Clause of the 14th Amendment incorporates the great majority of those rights and thus makes them equally applicable to the states. The second category, which is the one in question here, comprises a select list of fundamental rights that are not mentioned anywhere in the Constitution. In deciding whether a right falls into either of these categories, the court has long asked whether the right is deeply rooted in our history and tradition and whether it is essential to our nation's scheme of ordered liberty. And in conducting this inquiry, we have engaged in a careful analysis of the history of the right at issue. Justice Ginsburg's opinion for the court in Timms v. Indiana, Supra, is a recent example. In concluding that the Eighth Amendment's protection against excessive fines is fundamental to our scheme of ordered liberty and deeply rooted in this nation's history and tradition, her opinion traced the right back to Magna Carta, Blackstone's commentaries, and 35 of the 37 state constitutions in effect at the ratification of the 14th Amendment. A similar inquiry was undertaken in McDonald, Supra, which held that the 14th Amendment protects the right to keep and bear arms. The lead opinion surveyed the origins of the Second Amendment, the debates in Congress about the adoption of the 14th Amendment, the state constitutions in effect when that amendment was ratified. At least 22 of the 37 states protected the right to keep and bear arms, federal laws enacted during the same period, and other relevant historical evidence. Only then did the opinion conclude that the framers and ratifiers of the 14th Amendment counted the right to keep and bear arms among those fundamental rights necessary to our system of ordered liberty. Timms and McDonald concerned the question whether the 14th Amendment protects rights that are expressly set out in the Bill of Rights, and it would be anomalous if similar historical support were not required when a putative right is not mentioned anywhere in the Constitution. Thus, in Glucksberg, which held that the Due Process Clause does not confer a right to assisted suicide, the court surveyed more than 700 years of Anglo-American common law tradition, and made clear that a fundamental right must be objectively, deeply rooted in this nation's history and tradition. Historical inquiries of this nature are essential whenever we are asked to recognize a new component of the liberty protected by the Due Process Clause, because the term liberty alone provides little guidance. Liberty is a capacious term. As Lincoln once said, "We all declare for liberty, but in using the same word we do not all mean the same thing." In a well-known essay, Isaiah Berlin reported that historians of ideas had cataloged more than 200 different senses in which the terms had been used. In interpreting what is meant by the 14th Amendment's reference to liberty, we must guard against the natural human tendency to confuse what that amendment protects with our own ardent views about the liberty that Americans should enjoy. That is why the court has long been reluctant to recognize rights that are not mentioned in the Constitution. Substantive due process has at times been a treacherous field for this court, Moore v. East Cleveland, and it has sometimes led the court to usurp authority that the Constitution entrusts to the people's elected representatives. As the court cautioned in Glucksburg, we must exercise the utmost care whenever we are asked to break new ground in this field, lest the liberty protected by the Due Process Clause be subtly transformed into the policy preferences of the members of this court. On occasion, when the court has ignored the appropriate limits imposed by respect for the teachings of history, it has fallen into the freewheeling judicial policymaking that characterized discredited decisions such as Lochner v. New York. The court must not fall prey to such an unprincipled approach. Instead, guided by the history and tradition that map the essential components of our nation's concept of ordered liberty, we must ask what the 14th Amendment means by the term liberty. When we engage in that inquiry in the present case, the clear answer is that the 14th Amendment does not protect the right to an abortion.
Partout.
American Apologetic. A perusal of Dobbs v. Jackson. Leaked abortion case. Written and produced by Pacificatoris.
To be continued.